now in session. The Honorable Judge Timothy Williams presiding.
All right. Thank you, Marshall. And we're going to go ahead and have you get sworn in.
May be seated.
You do solemnly swear that you will keep this jury together in some private and convenient place, that you will not permit any person to speak to them, nor speak to them yourself, unless it be by order of the court, except to ask them whether they have agreed upon a verdict, and that you will return them into court when they have so agreed, so help you God? Thank you.
Okay, thank you. All right, let's go ahead and set forth our appearances for the record.
Welcome for plan instruction.
Oh, I'm sorry, Your Honor. Teddy Parker, good morning, Your Honor, again, on behalf of the plaintiff.
It's been a
Morning,
long
Your
3
Honor.
weeks.
It has been, Your Honor. 16-hour days.
Good morning, Your Honor. Robert Egglet for the plaintiff.
Brianna Switzler for plaintiff.
Good morning, Your Honor. Tyler Watson, Eric Freeman, Michael Esposito, and Brad Johnson's here somewhere.
All right. Okay, and it's my understanding we have an issue that has to be resolved regarding video deposition testimony. Is that correct?
Yes, Your Honor. Your Honor, in a nutshell, this is the deposition of Mark Rich. If you recall, he testified in the last trial by, I think it was by video, I can't remember. But,
You may. Thank you, ma'am.
So, Your Honor, Mr. Rich is the only witness that we'll call in the punitive phase if we have a punitive phase. And I think the fundamental objection here is the purpose of his testimony would be just to put the size of the bottled water industry into the record. And we do that on pages 1 through 9. And then when the defense cross-examined him, they engaged in a lot of questioning, which runs through this big company, little company theme, and we just don't think that's appropriate. So that's the fundamental dispute. It gets a little more in detail on specific questions, but that's the fundamental nature of the dispute. And as you remember, big company, little company was excluded by previous motion.
All right. We can hear from the opposition.
Sure. I think I can make fairly short work of a lot of this. We are willing to stipulate their objections in excluding all the large company, small company testimony, which I think takes us through their objections on page 24. So then we would pick up on page 26, starting at line 21. This is a question about whether one of the 3 designated companies, this actually happens, I think this is about half of what's left. There's a question about any instances of where these
Can you
companies...
give us a line in page
26.
Yes,
line?
26, 21.
20, oh, thank you, 21.
Yeah.
Okay.
So this is just a question about whether these companies that have been selected, if they've experienced the same adverse effect of their water production that happened with real water. Specifically, do you know if Coke has had hydrazine in any of their products? The objection on that was relevance foundation, that it's outside of the scope. Well, it's relevant because it relates to the risk that the jury is being asked to deter.
How, I mean, when you say it's relevant, how's it relevant?
Because it's relevant to the scope of the risk that the jury is being asked to deter. They're taking the 3 largest actors in the bottled water industry and saying that these are what we want to base the value of the company or the value of the bottled water market on. And we want to respond with, yes, but how broad is that risk? Because if the 3 largest companies have never had this issue.
But I don't understand the risk.
The deterrence is not for that specific, necessarily for a specific risk, Your Honor. That's not the purpose of punitive damages.
I understand.
Damages, exemplary damages. It's deterrence for any similar type conduct. And it's not just the hydrazine. There's a lot of stuff that they didn't comply
And I
with.
get
Go
it,
ahead.
but wait. I'm going to let him finish.
Okay.
Yeah.
We're all just chomping at the bit on
I
this one.
understand.
I know.
Go right ahead, Tyler.
No,
Sorry.
you can finish. Make your record, sir.
I appreciate your
Because then I'm going to tell you what my thoughts are.
All right. Yeah. We're too excited about this one.
Yeah, and as the court has previously indicated, especially as it relates to when we did the same arguments for Dr. Alsina. The opposing party is not bound by the scope of the other party's retention. You're able to fully vet and investigate the nature of their opinions. And so that's why we believe it's relevant. That's why we believe it's appropriate. Whether it's outside the scope is not a limitation for the opposing party. And for that reason, we would ask that these questions be allowed to be submitted to the jury.
Thank you, sir.
And so,
Okay.
and,
hear
Your Honor, there's...
Wait. I want to make sure he's finished, and I'll let you.
Yeah, I just wanted to know how the court wanted to handle it. It looks like there's 1, 2, 3, 4,
Well, I can
5,
tell you what my
6.
overall thoughts are once everybody's done.
Well, before we speak, we'd just rather hear your thoughts and we can respond, Your Honor, I think.
Well, everything I do, I try to, any of my thoughts are always tethered to case law, right? And here's my point. We have Ainsworth versus Combined Insurance Company. And that's a seminal Nevada case as it specifically deals with the issue of punitive damages. And there's a lot of issues there regarding punitive damages, but this is something that has been overlooked. I don't think we've done a deep dive on. And what is the purpose of the limits when it comes to punitive damages in a specific case, and what is the concern? There's a concern of annihilation, right? There's always, that's that outer factor, because if you have a functioning company, you don't necessarily want to punish them to the point where they go out of business, right? However, in this case, annihilation's irrelevant. They've already filed bankruptcy. And that's one of the main reasons why I did what I did in the prior cases. It's not relevant. And for example, straight out of Ainsworth, and this is at, I guess, head note 12, it says financial position of the defendant remains a relevant circumstance in evaluating the excessiveness of a punitive damage award. They don't function. They're no longer in existence. And so all that's left really and truly is, it comes down to this, deterrence. That's all that's left, is deterrence as far as punitive damages are concerned. And we can't overlook this fact too. Whatever the jury's award in this case is not unfettered, because at the end of the day, I have to conduct a State Farm analysis and make a determination if there's a proportionality to the award of compensatory damages. Right. And I've done it many times. Of course. And so at the end of the day, with the annihilation concern off the table, I think this is the only way we can go.
Right. And so, Your Honor, specifically though, with respect to this argument about, well, the deterrence is making sure that these other companies don't put hydrazine in questions, has Coke or Pepsi or Nestle ever had hydrazine in their real water. That is not the appropriate analysis of deterrence when it comes to punitive damages. The deterrence is to similar situated companies engaging in bad conduct. And also, it wasn't just the hydrazine. The company had virtually zero quality assurance. They didn't train their employees properly. They didn't do the correct testing on the water. They failed, all of these things. They didn't investigate their customer complaints. They just sent them more free water. They ignored all of these, as Mr. Kemp calls them, red flags, and literally had no ability or desire, more likely, to respond to them. So it's not just the hydrazine, and focusing on just the hydrazine.
It's the conduct, it's not the hydrazine.
It's the conduct.
I get that.
It's not the hydrazine in the water. It is the conduct, the outrageous conduct of this company that we're talking about here.
And we know why Mr. Kemp made references to red flags. That's straight out of Countrywide.
Right.
That's what the Supreme Court talked about. And there were a lot of red flags in this case. Mr. Parker, you wanted to speak.
He got 2 shots. He took mine on the second one. That's all right. I'm done. He got 2 shots at me.
Do you have any questions, any comments, Mr. Parker, for the record?
No, Your Honor. I think they've been covered by Mr. Kemp and Mr. Aglin.
We haven't heard from Mr. Kemp, though. Mr. Kemp, anything you want to
Nothing further,
add?
Your Honor.
All right. And I just want to make sure I take a quick look at this, because at the end of the day, and I do agree in this regard, because this is a really novel issue. I was thinking about it this morning as I was taking the trash out, because we had trash pickup day, right? I was actually thinking about it. And
I love you too. You took the stuff.
the size of the company, their finances, that's off the table.
Off the
You know,
table.
there's no annihilation concerns, because the company filed bankruptcy. And here's my point. I don't think the bankruptcy should be used as a shield against potential punitive damage claims in this case. Because when you really think about it, BK could come up again and again and again as it pertains to what does a trial court do when a defendant files bankruptcy. And in this case, there's a lot of, it's actually a two-level protection. And my point is this: number one, you got the bankruptcy court, and we know what bankruptcy court is: Chapter 7s, Chapter 13s, automatic stays, and all those things. And then and remember, this case has had the blessing of the bankruptcy court in that we can proceed to finalize the judgment,
That's right.
but there's still a protection in place, i.e., the bankruptcy. Number one. Secondly, when you look at this case, there's no financials to look at. There really and truly isn't, and that can't be overlooked. And the reason why you look at the financials is a concern about annihilation,
That's right.
and that's off the table. It's not
right.
relevant anymore.
You're ahead of the game now, Your Honor, because that's the next issue that's coming up. But that's exactly where we're going. You're right.
Yeah, Mr. Parker's right on that, because they seem to confuse the fact that Mr. Rich did the the cap analysis. What do they call it?
Yeah.
Well, the
Market analysis.
market cap, their market cap on Pepsi, Coke, and Nestle. But the thing is the value, the 100 million in America, that is all water companies, the smallest to the largest, and they seem to want to try to distort that, like he was trying to argue or allege that he only looked at the value of those companies. In fact, he looked at the market caps on those companies, but then he looked at the entire industry for their annual revenue or income, and that in 2025 is projected to be over $100 million, 350 million worldwide, $100 billion, excuse me, 350 billion worldwide, but in America over 100 billion. And so that is really the only number that counts here. And all this trying to focus and confuse the jury on these other issues to try to allege that they only looked at Coke, these three very large bottled water companies, is just not true. And it's not and again, the witness says that, Mr. Rich says that over and over in his deposition to them. So that part of it should be excluded as well.
Well, Your Honor, I would just ask for some clarification on the scope of this court's ruling. In the punitive phase, assuming that we move to that, are plaintiffs permitted to argue punishment of real water in addition to deterrence, or are they?
They're not separate. They go hand in hand. Deterrence is a component of punishment.
Understood. I just wanted the clarification on that, because I think that takes us to our next point. Well, actually, just for housekeeping, I think this court's ruling addresses then plaintiff's objection on 26 lines 21 through 27.6. Would you agree, Will? So that's out. I think the court's ruling also addresses the issue that started on page 30. Maybe it was on page 29 to begin with, because that's where we're talking about the same issue with hydrazine and Nestle. So I believe that's out, correct?
And this is important to remember. There's never been hydrazine in bottled water. That's something that doesn't happen.
Right. That's what we were hoping to get out. And I think HUD already testified to that.
Mr. Watson, can I
yes.
ask you one more
Trying to do the
point of clarification on 27?
Yes.
You said line 7?
No. Sorry, it's 26:21 through 27:6, I believe.
Why wouldn't it go to 27:11, where Mr. Rich says, no, that's not within my scope?
You didn't object to that?
Well, I think there needs to be an objection to that because he says it's not within his scope.
I mean, if you want to raise that with the court, you can, but that's not what was objected to here. So what I'm trying to just clarify
We're
right now is what we
objecting
just.
now.
Okay, well, let's stick with the housekeeping that we're doing right now.
Okay, go
So
ahead.
26, line 21 through 27.6 is out, correct?
Yep.
Okay, and then if we go to, I believe it's 29, let's start with the, where he's actually referencing hydrazine with Nestle. I believe that's,
Well, why don't we go in order? Why don't we skip 28, 17 through?
oh, because those are different
Conceding
issues.
that-
I was just trying to wrap up everything that the court had just
go ahead.
addressed. So I believe where that starts is 29, line 25 through 32. So that should be out.
Okay.
Because I believe that's the scope of the hydrazine in other products discussion. Then the other issue,
Okay, I'm sorry, go back, I'm sorry, Mr. Watson. Are you also going to address the titanium tube issue on that same page 29, lines 20?
yes, we'll get to that. I'm just trying to exclude the hydrazine stuff because the court just ruled on it.
Okay.
Any others, Tyler?
I think that's the only two times that the issue with whether there was hydrazine in the other company's products came up. So I think that wraps up those issues.
All right.
Okay. So
Okay.
What do you want to go back to?
Yeah, so then we would go to 28 lines 17 through 19, and then I think an associated issue would be 29 lines 10 through 13. These are questions about whether the expert looked at the sales that Real Water had at a relevant time period and whether he looked at the percentage of the market that Real Water occupied.
Well, that wouldn't be relevant because
It's
that's
not relevant,
small
Judge.
company, big company.
I mean, I think I've already said that, right?
Yeah.
Right.
Over and over.
Yeah, I mean, because once again, what's the purpose of punitive damages to deter? Why do we look at financials? Because we don't want to have annihilation, right? And there's no annihilation in this, concerns in this case, because of the filing of bankruptcy.
And if you recall, Your Honor, on the first trial, when this was attempted, we also found out that the sales information they had was outdated. It was nothing,
6 years old.
it was 6 years old, that's correct. And you said it wasn't even appropriate to use something that old.
But we have to remember, what's the purpose of annihilation concerns?
Right.
To protect the company, right? Because you don't want to put them in bankruptcy or anything like that. For example, you had a small mom and pop with gross income of $200,000 a year, a little corner store, right? Maybe $50K punitive damage would be appropriate for them, but not $250 because they'll be put out of business.
Absolutely, Your Honor.
You know, it's punishment and deterrence. There's no concern today about putting them out of business. They're out of business.
They're done.
And I understand the court's ruling, and I'm not trying to swing after the call's been made, but just for the record, to the extent the court has determined that punishment is still a factor, we would argue that we need to be able to explain what percentage of the market we occupied for that punishment.
There's
And again,
nothing, no, and trust me, you can make your record, I respect that, but there's nothing to punish.
We've
Right.
been arguing deterrence the last several trials, Your Honor.
Yes, I mean, because and here's what's really fascinating about it, and I think this is kind of overlooked, but this is what I'm hoping the Supreme Court will look at this matter in this regard. If annihilation is off the record, the financials become irrelevant.
That's
I
right.
don't think it's been articulated that way so far, has it?
No, that's exactly right, though, Your Honor.
I mean, and so all we're left with is deterrence, right? And just as important too, and can't be overlooked. There's a buffer there too. There's a protection because there has to be proportionality as it relates to the punitive damages to the compensatory,
That's right.
and that's still available
That's right.
because in every case I've had punitive damages, I've limited as required under State Farm, and I do realize there's some cases after that might, may give it a little bit more, but I've been right around 10.5%.
That's right.
Yeah, and that's what I've done historically.
So 28, 17.
Right, ma'am? It makes
28,
perfect
17,
sense, doesn't it?
Absolutely.
Correct.
Okay, where are we going next?
I think that covers, under the court's ruling, 28, 17 through 19 is out, and 29,
That's all out.
10 through 13 is definitely out. Then the next issue, I think the court's ruling covers this as well.
The titanium tubes.
Yeah, titanium tubes from any other company.
Okay, that's out.
And I just want the court to go on record.
Oh,
make sure that's
so wait a
the
sec,
ruling.
wait a sec. That would also go all the way up to 14, because that talks about the electricity being used.
Yeah, that's what we're talking about right now.
Okay, it's 14 through 21, correct?
And.
Yeah, I was asking
And
you-
on to line 2 on page 30.
Oh, we already
We got
agreed to
that.
that part being out.
Yeah.
Yeah, so 23, sorry, on page 29, 23 through 25, and 31 through 2 is already out. So right now, we're just talking about 29, lines 10 through 21, or sorry, 14 through 21. And I believe the court's order covers that would be excluded, but I just want to make sure on the record that that's the ruling.
I thought it's actually, I'm sorry, Mr. Watson. I thought it was 14 through 25 is gone now, all the way through page 31 through 5.
Yeah, I'll break it down one more time. So
Trying to do
on
that
page
now.
29, the court just ruled 10 through 13 are out. That's done.
Okay.
On the previous issue that we were arguing, the court ruled that 29, lines 23 through page 30, line 2 are out. So now we just have this chunk on page 29, lines 14 through 21. It's 2 questions, one about, do you know if Coke uses electricity to make alkaline water? Do you know if Pepsi uses titanium tubes to make alkaline water?
Yeah, Judge, in our position's
That's not
consistent.
relevant, Al.
Yeah, it should be.
Understood.
It's a broad-based deterrence. It's not focused. Yeah.
So that goes through page 30, lines 2.
Yes.
Okay.
Correct, Tyler?
Yeah, that was
Okay.
already out, but yes, you're
Okay.
right, that's all excluded.
All right.
And I think the only other issue
31.
was page 37, is that right, Brianna?
I'm sorry, what was that?
I think the
37.
only other objection that still stands is page 37.
I didn't hear you address 17 unless you withdrew that one.
Page 17? Yeah, at the start I said we stipulate to everything that you objected to through page 24.
Okay, sorry.
Okay, so where are you at, Tanner? Where are you at now?
I believe the last issue that we have is page 37. I just wanted to make sure that everyone agrees.
Unless they're adding that to the objection. Are you guys okay with everything on?
Yeah, we had another one we talked about a little while.
And we'll stipulate to 37, Your Honor.
Okay, that makes it easier, quicker.
11 through 18. So page 37, 11 through 18, we'll stipulate to removing.
Okay, so there's only one other thing I thought we had.
So I have some additional objections, Your Honor. On page 27, where he's asked, I want to talk generally about your research into the bottled water industry. Did you make any effort to carve
Sorry, what
out?
line are you starting with?
7.
7.
Oh,
11.
okay.
All right, I want to talk generally about your research into the bottled water industry. Did you make any effort to carve out the bottled water industry alkaline water production? No, that's not within my scope. Your Honor, that's not relevant here as to whether it's just alkaline water. And, you know, this is deterrence of all, to all bottled water companies, and because it's not just the titanium tubes, it's not just that they manufactured hydrazine into their product, it's all the other stuff too.
It's water.
It's
I'll
water.
be candid with everyone. I had no clue until I had the first real water case there was such thing as alkaline water.
Right.
And then that, and goes along with that is on the same page, lines 25, starting on 25 through line 2 on the next page. Okay, so had it been in your scope, you could come up with whatever that percentage is related to alkaline water. That should be out as well.
Well, here,
And again, this goes on 27. It actually goes 12, line 12. Okay, do you know what percentage of the bottled water industry is related to alkaline water? I don't know specifically. I do know that it's a much smaller portion than, general water that we could say that you could drink. Is your knowledge in this regard anecdotal, or do you have some basis? I think I have a general knowledge that know that it's smaller, but specifically no, I don't know the percentage, and that wasn't within my scope. Otherwise, I would provide that. So again, basically, it's all of page 27
28.
through lines 2 of 28.
Line 16.
Four.
16. Go all the way to 16.
Yeah, and all the way to 16 on lines 28. Excuse me. Thank you, Mr. Parker.
No worries.
That's all about this, alkaline water, and this all should be out, Your Honor.
We hear from the defense.
Your Honor, our position, and we've argued it throughout the scope of this case, is that this portion of their argument is overreach. It's dramatic overreach, and we should be able to argue that to the jury when placing a value on this. The risk here was really unique. No one had ever seen it before. So expanding the punitive analysis to the entire bottled water industry is grossly misleading to the jury, because this is not a risk that exists throughout the bottled water industry. It's not even a risk that exists to the alkaline water industry, because no one else does it this way. So while we understand that the plaintiffs are allowed to present this argument, we would argue that we should at least be able to point out that the figure that they're giving is much broader than the industry that's actually at issue, which is an alkaline bottled water industry. I mean, what's the outer limit of this argument? Why not the entire food and beverage industry in the entire country? Why not the entire food and beverage industry in the entire world? At some point, we have to say this is broader than the issues that created the risk to the public in this case.
It's
Well,
not broader
I can answer that in a way. I mean, for example, you said the entire food and beverage industry, we wouldn't have Buffalo Trace as
Right.
part of this, right?
That's right.
A bourbon manufacturer, we wouldn't have
That's good
Jack
stuff.
Daniels,
That's
we
right.
wouldn't have Diet Coke as part of this.
But we do,
Right.
Your Honor. We
No,
have
we don't. We're
Frito-Lay,
talking
we have
about-
Doritos, we have Gatorade.
No, there's a difference between who owns, for example, Desante.
That's right.
I mean, and so Desante becomes part of the bottled water industry.
And
And
it's-
their
and this-
sales volumes.
And this just isn't, it keeps focusing on hydrazine, Your Honor. This just isn't about hydrazine. This is about all the other things that go into this punitive damages package of their failure to investigate their complaints, their failure to have any real quality assurance in the program, ignoring all of these red flags that Mr. Kemp pointed out and Mr. Parker pointed out and I pointed out throughout this trial. It's not, the hydrazine was what happened, but it was all of these things that contributed to that and contributed to them not actually realizing, allegedly, that they weren't manufacturing hydrazine into their product.
Yeah, Judge, and I would point out philosophically, when we first looked at this issue, we thought the food and beverage industry philosophically was the deterrent point. And that's because, for example, quality assurance is not just beverages, it also runs to food. But our position analytically was that we didn't need to go that far because we knew that the amounts we were talking about would not survive a state farm analysis. In theory, we could be asking for trillion-dollar verdicts to deter the entire food and beverage industry. We didn't want to do that. That's why we got super conservative and we just took the bottled water industry. And so I thought that was a real conservative approach on our end. But philosophically, you could extend it further. But now they want to say, well, not just the bottled water industry, we want subparts of the bottled water industry. And I think that's just cutting it too fine. That shouldn't be allowed.
I mean, what are we gonna do? We're gonna have, if it's flavored water?
Yeah, Judge.
I mean, it just goes on and on.
This bottled water, when you walk down to the shelf at Whole Foods or Sprouts, there's not a lot of distinction between non-alkaline, alkaline plus, alkaline with cherry. It's hard to say where it stops and where it starts. Other than that, it's bottled water. So I think our approach was conservative, yes, but I think it was appropriate in the contours of this case.
And Your Honor, before I want Mr. Tyler Watson to be able to address this all at once. I would also direct the court's attention to page 31, line 15 through 33, line 25. It's Mr. Johnson's recross, which I believe touches upon the same issue.
And then, Your Honor, additionally, on lines what page were you on?
31 through 33.
Were you guys not afforded an opportunity to look at this yesterday? I mean, we got their
Potentially
objections, and now
not,
they're.
but that's okay. That's
Well,
all
I was
right.
prepared.
I didn't see this. I didn't get
We
this.
wrote an email.
We were
I didn't
more
get this.
efficient than they.
At any rate, I mean, we've all been very busy, Your Honor, but at any rate, page
Trust
13.
me, I have.
Why don't we
all
go
the
back to
empathy.
27 and just
Yeah.
do this
I have all the
methodically?
empathy in the
All
world.
right, let's go back.
I do.
27.
Let's go back to page 27, because we haven't addressed that issue, Your Honor, and that's line
7.
7. 7, all right. I want to talk generally about your research into the bottled water industry. Did you make any effort to carve out from the bottled water? Well, I thought we talked about the alkaline product.
did.
We
but we
did, we
didn't get a
did. We just need a ruling.
Yeah. So I think we got a ruling on the alkaline, didn't we, Judge?
If we didn't, I'll give you one right now. Once again, I'm not going to limit the thrust and focus to alkaline water. It's going to be the bottled water industry.
Thank you.
So that would be page 27, starting on line 7, all the way through page 28 through line 16.
19.
What?
19.
19, excuse me.
That's
Yeah.
out for
That's
different
out.
reasons.
Yeah, right.
And then, Your Honor, what I,
Well, sorry, can you say that again?
27/7 through 28.
19.
16. 17 through 19 is already out.
yeah, that's out.
right.
And then, Your Honor, on page 35,
Well, wait. Let's
all
let
right,
the defense
all right,
get
sorry,
that.
go ahead. I'll wait till
Since-
you guys get to 35. Go ahead, Will.
Since we're cutting out whole pages on the fly, we have a minute to take a look.
Take your time.
He said you have to tell you story.
Yeah, then we go to 31.
And then what Mr. Parker just brought up on page 31, lines, is that
Wait.
6?
Let's just make sure we got this. We're in agreement on this?
Well, you want to go through methodically all the way through probably everything that's out. Is that right, Will?
Yeah.
Why don't you do that, okay?
Okay. So we're 27/7 through 28/16 now?
Yep.
Or 2819, actually. And 2819.
Yeah, yeah,
Okay, what's next?
okay, okay. All right, next would be, I believe, 31 is what you guys
Yep,
want to do?
31.
You got-
15.
Are you going through all that's out?
Yeah,
Okay, well, you start at 29, there's stuff out.
Yeah, I have 29, 10 through 25.
Yes.
that's already
Yeah,
out.
that's all right.
Yeah.
Well, yeah, but I thought we were confirming what's out.
Okay,
then.
yeah, confirming
And then-
29/10 through.
31,
It's actually 30,
35.
30 through 5.
Goes
because
through
the-
5, yes.
Yeah,
He can't say, I don't have any further question? And pass the witness?
Oh, go ahead, I don't mind.
Yeah, that's fine. So through 2.
Okay, so we're up to 31/16 now, right?
Yep,
All right.
all the way through 33:25. Unless you want to say thank you. Are those all the questions I have? Thank you.
Yeah, so 3116 is what Mr. Parker argued, and that's through where?
Oh, well, we definitely have some issues there.
Okay, well, let me
Yeah,
just get,
so-
Why would
So
you?
we don't have a
to the
ruling
end
on
of
that
35.
either.
all the way to the
To the
end
end
of,
of 33.
end of page 33.
Why would you want a bigger deterrence number? than
33 what?
16.
16.
31/16.
Through 33:25.
All the way through 33. Well, I think you can,
Unless you want to say those are
You
all the
can-
questions I have,
yeah.
Mr. Rich. Thank you for your time. Thank you.
Well, you already
so
said-
22, through line 22.
Okay, and what's the basis for your objection on those 3 pages?
Well, you're going back trying to carve out some alkaline or water issue with Pepsi, Coca-Cola. That's what you're trying to do.
Talks about alkaline water in here. Talks
You know
about-
what, here, this is an important point too, because at the end of the day, we have to remember what guides the law in this case, and that's the restatement of torts 402A, and as the Supreme Court recently made a determination that under Nevada, we follow the consumer expectation test.
right.
Under the second restatement, not the third restatement.
That's right.
And here's my point. When you go buy bottled water And I don't mind saying this, I probably have purchased alkaline water and didn't even realize I was purchasing alkaline water. I didn't even know it existed until this case. And here's my point. That's why I'm limiting the scope to bottled water. It's not gonna be some subset of bottled water. It's gonna be bottled water.
Well,
You
Your
know?
Honor, and I appreciate that ruling, but this testimony they're asking to have cut out proves that that is not what Mr. Rich is testifying to. He was asked specifically in these 3 pages that they're asking you to whole cloth dismiss. When you talk about,
Wait, say that again, I wanna make sure I understand what you're saying. I'm listening.
he is asked, when you come up with the figures for Coca-Cola, is that the water, the bottled water portion of the company, or is that everything they make? Same question for Pepsi. Is that just water or everything they make? Both answers, it's everything. We did not separate the water out at all. Question, the 270 billion market cap that you noted in your report as related to Coca-Cola, is that for all of Coke products or just the water? It's Coca-Cola. So that's everything that Coca-Cola does? That's correct. Same with Pepsi, which again, Doritos, Frito-Lay, any number of products that have nothing to do with water.
This is a continuation of trying to.
Your Honor,
The jury does need to be able to be informed that this is much broader than just the bottled water industry, the numbers that are being presented.
it's not, because in my closing argument on punitive damages, I'm not gonna be talking about Coca-Cola and Pepsi and Nestle's market cap, okay? When he did his analysis of the bottled water industry at 100 billion, and obviously all of Nestle and all of Coca-Cola and all of Pepsi aren't part of that because their market caps are significantly more than 100 billion. That is specifically the earnings for bottled water in 2025, nothing else. This is just an effort to confuse the jury, but them to confuse the jury with these market caps that have nothing to do with what our argument is being. I will tell you that the court, as an officer of the court, myself and Mr. Parker will only be talking about the $100 billion number in earnings for 25 for just bottled water sales.
Yeah, Judge, I don't think the defense has thought this through, because just because we put these figures in the report, 270 and 300, they're not gonna go in front of the jury. The report's not admissible. So I don't know why they would want us to have another 270 billion, another 300 billion from Pepsi, and, be able to amp it up to, 500 billion. I just don't see their rationale for that. So
I can assure you, as an officer of the court, I'm not going to say anything about these market caps. I'm going to be talking solely about the $100 million.
Billion.
I keep saying $100 billion in earnings the bottled water company will have this year, and Mr. Parker will be doing the same. We're not going to be talking about these market caps.
Yeah, Judge, this kind of gets into the big company, small company. They're just trying to show some of these companies are big companies and imply they're a small company. So I think it should be out for that reason. But also, like I've already said, I think I wouldn't call it suicidal, but I wouldn't do this move if I was a defendant and having more billions flying around.
Well, while I appreciate Mr. Kemp looking out for us, Your Honor, we're not bound by the arguments they're making in their punitive phase. They do, though, have to accept the fact that this is part of their expert's testimony. It's on the record, and we can reference it.
No, that's a
that's
basis.
not-
Not if it's relevant. It's not relevant.
not
It's not
irrelevant.
relevant here to the punitive damages
It's in his
analysis.
report. It's not in his
I mean, if everything,
right here.
if every
It's in
comment.
the testimony. That's what you're asking. to
No, let's keep it
in the proposed
out
testimony.
what the law mandates. Just because somebody testifies to it doesn't mean it comes in,
Right.
right?
That's right, Judge.
I mean, that's pretty basic. And I don't mind saying it, my decisions are gonna be in accord with all my prior decisions specifically on this issue. I'm not gonna deviate.
Your Honor, I appreciate that, and that's one thing I wanted to address that I don't believe has been addressed. And I don't fault Mr. Watson for this, because he's not attended all of the other trials. We have never, in the life of this case, put up Coca-Cola's, Pepsi's, Nestle's, any of their market caps. We've never done that. We've stuck to the bottled water industry numbers, period. The report goes through several market caps for these companies, but we've never put that in. You've never allowed us to put it in. We never proffered that information. And for some reason, if the defendants wanted to make that an issue, they didn't do it during trial. And we don't intend to do it in our rebuttal arguments, Your Honor. This is an attempt, and I think it's a way of trying to circumvent the court's rulings on motions in limine to get this big company, small company issues out there. And that's what they're trying to do. They're going to say, well, they're going to use this to suggest to this jury that this is not Coca-Cola that's at risk here. It's not Pepsi, it's not Nestle. And they had $270 million market caps each. Billions. Now you got me saying it. $1 billion market caps. We're not going into that.
There's an important reason for that. They filed bankruptcy.
That's right. It has no relevance.
If they hadn't filed bankruptcy and if they were an ongoing company, we'd be using their financials.
And perhaps they'd have their own expert, which they didn't bring.
But
they didn't proffer their own
it
expert.
doesn't matter. We would still be using
Bankruptcy?
It doesn't.
No, if you weren't in bankruptcy.
Here's my point, and this is a very important point. If they weren't in bankruptcy, we would be using their actual financials.
That's right. And they would probably have their own expert. But they don't have either. They're in bankruptcy, so they're trying to use it as a shield and a sword. So it's not relevant. The annihilation issue is not relevant.
That's what I said when I first hit the bench.
And you're right. So this is, again, an offhand way of trying to circumvent the court's previous rulings.
And we can't overlook this. Once the annihilation issue becomes irrelevant, there's still safeguards in place based upon due process and the 14th Amendment as set forth in State Farm.
And in this court, because it's my understanding between Mr. Eglett and Mr. Kemp, you've given one of the largest haircuts on a punitive damage case, I think, in the jurisdiction.
Probably, huh?
Yeah.
I did.
I think.
Judge Hardy beat you.
Oh, did he? Oh,
Did he? Well, you're number two now.
But here's my point. I did what State Farm mandated.
That's right,
No,
John.
you did. You're a judge.
I mean, I did what the law mandated,
understand
right?
that.
I mean, at the end of the day, I went back, conducted the appropriate analysis, and did what I was required to do by our U.S. Supreme Court.
That's right, John.
That's right, Your Honor.
Oh, wow, they have a verdict.
All right, well, we have to get this finished, Your
I
Honor.
understand.
I think we've made our record unless there are new objections.
No, I still got another objection, Your Honor, here. On page,
So wait, to clarify, 31 through 31, 15 through 3322 is
out, yes.
Yes.
And Judge, I just want the record to reflect that the defendants have taken the position that the market cap of Coke and Pepsi are relevant. And I think the record should reflect that because they've taken exactly the opposite position in the past cases.
But I'm not gonna, I mean, I don't know that.
I'm not arguing with you, you're ruling, Your Honor, I just
Oh, I understand, you're just making this, okay,
have trouble.
okay.
Your Honor, then, on page 35, if you look at Mr. Johnson's examination of Mr. Rich, starting on lines 4 through basically page 37, lines 10, what Mr. Johnson is trying to do here is trying to use Mr. Rich, and this is not part of his scope of his work, it's not part of his opinions, to impeach another witness in this case who talked about when he worked at Nestle, I can't remember who that was, and they had 10 plus out of 10 on their, their audit. And he's trying to get him to impeach him where he says, well, I've never seen a 10 plus 10. I wouldn't think that was, possible, blah, blah, blah. I mean, that has nothing to do. It's not relevant to this witness's testimony. It's just an effort now to try, after the trial's over with, and the issue of whether punitive, since it looks like we have a verdict, the issue of whether punitive damages box is even checked yet, it would go to that issue. But this is totally improper, using this other witness to try
All the
to...
way to 37.
Yeah, it's all the way to page 37, lines 10, Your Honor.
Through 15.
Well, 15. Well, 11 through 18 has already been ruled out.
Right.
But through lines 10. I mean, what does that have to do with the accountant who's coming in giving us, what the value, the earnings in 2025 of the bottled water industry will be. Nothing. It's not relevant.
The relevance is that he said in his testimony that the numbers he was putting forth were for the purpose of deterring the industry. So the question was, does the industry actually need this deterrence? Any of the companies you've looked at, do they have any of these risk factors that exist in this case? And he said, no, I haven't seen it. To the extent the argument is that that's beyond the scope of his retention, I would remind this court that Dr. Alsina was asked about the moral obligation to cover emotional damages in a civil litigation case, clearly outside the scope of his expertise and retention, and the court allowed that.
Okay,
Well, that's a totally different issue.
Totally different issue.
Doctors can opine on issues regarding
And Dr. Rich isn't
psychological
on morality.
damage.
Dr. Rich, or Mr. Rich is not an expert in audits and analysis of whether companies are acting appropriately. He wasn't designated that way, and they can't try to turn him into an expert through this examination of Mr. Rich.
I'll make it real simple. It's not relevant.
Thank you, Your
It's
Honor.
not relevant. It's not. He's not an expert as far as manufacturing processes is concerned vis-a-vis bottled water companies. It's not.
Thank you, Your Honor.
Well, he said he testified that he'd been involved in audits of these companies. Your
But
Honor.
he's not, is he involved in production?
That's right. That's the point. Financial audits.
Is he
He's
involved
not
in
Dr.
production?
Hutt.
I mean, come on.
That's it. Thank you, Your Honor. I think that's all we have, Your Honor.
I think we have an agreement on, to the extent it's necessary, we have an agreement on punitive damages instructions.
Okay.
Is that correct, Tyler?
That's my understanding.
So
Mike?
Go ahead, sir.
we do, Your Honor, we are going to have one issue with regards to arguments raised in prior cases with regards to punitive damages, but I think that can wait until we know whether or not there's an actual word of punitive damages in this case.
Your Honor, I do have a question. I mean, it's going to take us a minute to get this cut.
Yeah.
I mean, we're not ready.
Well, I understand.
Well, can we take the verdict and then
Oh, we're gonna.
let them go for while we get cuts
We're
made and all
gonna
that
do what
stuff?
Mr. Parker, you've been here many times. What am I gonna do?
You're gonna work with both teams.
Yes, absolutely.
Also,
Thank
we
you.
do have lunch coming at 2 for the jury.
At 2 o'clock.
And Your Honor, just to answer opposing counsel's question, yeah, we do have the stipulation on the jury instructions. The verdict form is something that needs to be determined.
Yes.
Okay, well, let me see the verdict form.
Well, wasn't expecting jury to come back so quickly, Your Honor. I-
I have plaintiffs, Your Honor.
Do you have our copy too?
I don't, I was ready to.
Okay, yeah, so Your Honor, I'd have to go across the street and grab our copy.
Yeah.
Oh,
get it.
yeah,
But I'll just,
actually,
we
hold
can
on.
at least proffer it
Yeah,
and then you
give-
can.
one moment.
Can you print it? Do you have a printer, sir?
Yes. 1 second, Your Honor.
Are you done with the deposition?
Yeah, Tyler and I will
Here you go.
work on making sure everything.
Yeah.
Yeah. everything.
Appreciate it.
Your Honor, may I approach?
Yes, you may.
Here's our proffer to punitive damages verdict, which is the same as the prior.
You're in the camera shot today.
I'll tell you right now.
I think objections that we got.
Yeah, one liner.
Judge, you
I think
have their,
I'm sorry?
where's it? Where's it at?
They don't, I don't know, they have printed it out.
Are you tendering different form?
Yes.
Again?
You guys should have different form?
I don't know.
Are you guys okay with this? Or we gotta argue about this?
The punitive damages verdict form, we're printing our proposed copy out right now.
Can you print a copy for Mr. Knight, please?
I assume we were, yeah.
Or email it to me?
No, Robin's printing a copy.
Perfect.
Yep.
She's not here for you. Okay.
So,
Okay. Okay. Proton?
Yes.
This is defendant's proposal.
Thank you, sir. All right, we'll deal with the verdict form right now. Why shouldn't I use the same verdict form I used before? What's wrong with that?
Judge, I think you should. Their verdict form, I think, has a fundamental misconception of punitive damages. There should be one award of punitive damages, not multiple awards to 13 different plaintiffs. I think their verdict form lends itself to extremely excessive verdicts. I mean, I can see the jury putting a billion here. I just don't think that's appropriate, but conceptually, we are not awarding punitive damages to individual people, okay? We're awarding punitive, and the plaintiffs have to be in the case, so it's tied to their group compensatory, but it's not as if it's an award. It's a societal mechanism to try to deter misconduct. That's what it is. It's not that's why you don't look at compensatory damages for the basis of the punitives, except later on when you apply the constitutional ratio. So this verdict form they've got with 13 separate punitive awards just doesn't make any sense.
Thank you, Mr. Kemp. Sir?
Your Honor, to answer your question, Mr. Kemp kind of hit the nail on the head here. NRS 42005 subsection 3 requires a special verdict be entered for a punitive damages award, not a general verdict. The anticipation is, as the court has said repeatedly throughout this trial, that the court is going to be tasked with applying State Farm and otherwise determining the excessiveness of the award. In order to properly do that, the court is going to need, this is I think the fundamental disagreement here, to evaluate compensatory damages as to each plaintiff. So we are asking the court, we believe the interpretation of NRS 42-0053 requires a verdict form of this nature, and that we obviously defer to the court's discretion.
Yeah, Judge, I've done a lot of multi-plaintiff cases. I've never even seen something like this proposed.
You're right. It's the sum of the compensatory damage of all the plaintiffs that's looked at when the punitive damages.
Yeah, Judge, and you have the right to review the compensatory damages on an individual basis before you do the State Farm calculation. And we're not.
And that's exactly what I'm going to do.
Right.
And I've done in the past, right?
Yeah.
So to do so, Your Honor, we would want you to have the opportunity to review what the jury believes the punitives are as to each plaintiff compensatory to their case, so that it is directly tied to whatever the compensatory value is in each individual case, pursuant to the jury instruction that requires the jury to value each case independently of one another.
Your Honor, I think it also goes against the jury instruction itself. It says here, the amount of punitive damage award is not to compensate the plaintiffs. So why would you identify each plaintiff? That makes no sense. That's what the pattern jury instruction says. That goes against it. Exactly, Your Honor.
You know what? I was going to take a look, but I think Mr. Park, you hit it right there. It's not to compensate.
And the reason I remember that, Your Honor, you and I, everyone had that same discussion when we did the first trial.
Yes, I remember. I'm going to go with for the record, I'll go with the punitive damage verdict form I used before and the other two prior trials.
Then, Your Honor, we just ask that our verdict form be lodged.
Oh, yeah, we'll have it marked.
Thank you.
Okay. So how much time do we need in between as far as the jury is concerned? Because we're going to take a little bit of time and potentially.
You have a copy of the regular verdict?
We're working on the cut right now, Your Honor.
We do have a trial brief on a discrete issue, Your Honor. We'd like to have the plaintiffs have the opportunity, the court have the opportunity to review that. So we'll be filing that here entirely.
And what discrete issue?
And what would that be on?
It's based on Philip Morris v. Williams, Your Honor,
I mean,
which
you
I
can
know
lodge it.
I know the court is very familiar with.
Yeah, but my point is this, I've already ruled. You can lodge it, but it wasn't argued and presented to me before ruling.
Ruled on what, Your Honor?
You're talking about punitive damages and the verdict form?
No, Your Honor, absolutely not.
What are we talking about then as far as beef is concerned?
I mean, I can do this right now on the record. I was trying to give plaintiff's counsel an opportunity to review, but Phillips v. Williams expressly states that you cannot introduce evidence of injuries to third parties or non-parties for the purpose of establishing a punitive damages award. That is an unconstitutional basis. There's two public policy reasons behind it. The first being that the defendants have not presented a defense as to the nature, scope of the injuries to third parties. And the second one being that it requires rank speculation on the part of the juries. Now, I know from Brown that Mr. Parker got up and repeatedly referenced everything from dead cats to, Susan Doran, to babies, a lot of things that aren't available in this case. And we do have those citations to the transcript if the court would prefer them. But the fact remains that regardless of the nature of the conduct here, the U.S. Supreme Court in Williams examined this exact issue and said, for the purpose of determining whether or not the conduct was reprehensible, this information is allowed in. That's also Wyeth v. Rowett, which the court is very familiar with. However, the distinction is once you enter the punitive damages phase, that information becomes an unconstitutional presentation to the jury. So under Williams, all we're asking is that plaintiffs preclude any reference or any argument or any testimony relating to injuries to non-parties that could influence the amount of the punitive damages award. And that's black and white law out of the U.S. Supreme Court. That is good law.
Yeah, Judge, the Philip Morris case, I actually had some involvement in that case. In that case, what happened, that was Mike Williams out of Oregon, and against my advice, he argued that the jury should punish Philip Morris for sales to 245 million smokers or something like that. I can't remember the number. But he included smokers both inside and outside the state of Oregon in that. And so when that case went up, the court said you cannot punish people for out-of-state conduct. It wasn't non-parties, as counsel has said, it's out-of-state conduct. So what he should have said, and what I told him to say, is you should punish for the sales to these people in Oregon, and he didn't say that. So that's where the extra...
This kind of came up tangentially in one of our cases.
It did. That's right. It came up in it also came up in the HMO case, Your Honor.
Yeah, Judge, so we're not going to be arguing that they should punish the jury for water sales in Florida, okay? We're not going to be saying, okay, Mr. Fisher got injured, you should punish because Mr. Fisher also got injured. So it's just not an issue, Your Honor. And if it is an issue, and we do go past those bounds, I'm sure counsel will file an appropriate motion at the end of the case.
Right.
Respectfully, Your Honor, to any involvement that Counselor Kemp could have had in this case, I read it this morning, just to make sure that we're on the same page.
Boy, that makes
The issue of whether or not it was out-of-state conduct is entirely irrelevant to the court's decision. The Supreme Court said, and I'm quoting here, the Constitutional's due process clause forbids a state to use a punitive damages award to punish a defendant for injury that afflicts upon non-parties or those whom they directly represent. It inflicts upon those who are essentially strangers to the litigation. Reaching this decision, they were examining conduct in and outside of Oregon, but they were not saying that there is a jurisdictional restriction on which non-party injuries can be allowed. The two policies include prohibiting a state from punishing an individual without first providing that individual with, and I'm quoting here, an opportunity to present every available defense. Secondarily, the U.S. Supreme Court found that to permit punishment for injuring a non-party victim would add a near standardless dimension to the punitive damages equation. How many victims are there? How seriously were they injured? Under what circumstances did injury occur? The trial will likely not answer such questions as to non-party victims. The jury will be left to speculate, and the fundamental due process concerns to which our punitive damages cases refer, risks of arbitrariness, uncertainty, and lack of notice, will be magnified. The court found these policy concerns, the court found this reasoning, irrespective of whether or not the conduct was inside or outside of Oregon. The court has said, excuse me, Counselor Kemp, I'm going to finish.
The whole case? Are you kidding me? Go ahead.
I'm not kidding you, Counsel. The U.S.
No,
Supreme Court has said, as it pertains to non-parties, which in this case involve cats, babies, airmen, literally anybody else aside from the plaintiffs that drank real water, The U.S. Supreme Court said to introduce that as
the
unconstitutional.
thrust and focus was on hydrazine exposure.
Yeah, Judge, I was nice at the beginning. I'm not gonna be nice now. Philip Morris says you have to tender a Philip Morris instruction. That's what the defense should have done if they wanted to make a Philip Morris argument. They have not tendered a Philip Morris instruction, so they have waived this argument at this point. Everything counsel is saying should have been put in a tendered jury instruction. If he wants to look at the Philip Morris case, the Ninth Circuit case law, that's exactly what it says. So counsel should be saying to the court, Judge, I have forgotten to do a Philip Morris instruction. I want to raise this at the last minute. He can't do that, Your Honor. That should have been tendered as a Philip Morris jury instruction at the time of jury instructions being tendered. And also, I think I pointed this out to him when we were arguing motions to eliminate. I pointed out that he needed to tender a Philip Morris instruction and that we would probably agree to it. But he didn't do it. So he can't come in here at the last moment and try to do some kind of Philip Morris prophylactic on the closing argument, which is what he's trying to do. Your Honor, he's waived the jury instruction. That's gone. That's gone. The Philip Morris argument is completely out of the case. He can't raise it after the verdict. You know, he's blown it for his client. I told you I'm not going to be nice, but this is ridiculous, Your Honor. When he hasn't tendered the instruction to argue now that there's some kind of consequence for his failure to do that. Show me the instruction you've tendered.
I'm not
Show me
trying
the
to
jury
jump in.
instruction.
I'll let you respond to it, sir.
Okay.
And then we'll do that.
All right. For the record, in the Williams case, there was a recommendation as to the utilization of the jury instruction. That was not the basis for the finding on the unconstitutionality of the argument. The underlying fact remains, regardless of whether or not Mr. Kemp wanted us to proffer a jury instruction, the Supreme Court found as a fundamental matter of constitutionality in the defense on the cap or the ceiling that this court is going to determine on excessiveness. The U.S. Supreme Court simply stated, introducing injuries of non-parties violates two essential public policies that protect the defendant in the event that punitive award is entered. Now, there's no waiver of that constitutional protection simply because Mr. Kemp wants a jury instruction similar to one that was proffered.
I don't want a jury
in
instruction,
Williams.
Your Honor. It was their obligation to tender it. If he really had done the research, he would find out that there's Ninth Circuit cases subsequent to that saying that the defense have to tender a jury instruction. They didn't do that. That's the end of this issue.
Counsel, if you have a citation for me, that's fine, but I'm relying directly on what the U.S. Supreme
You
Court
haven't
said.
given me
Your
the
Honor.
bench brief.
I don't, Mr. Kemp is not the attorney and the judge in this case. We like to make our record and get a ruling.
I'm letting everyone make a record.
So let's make the record. Finish up. Let's get moving.
Yeah, we have nothing further, Your Honor.
I have nothing further other than that they've conceded the instruction hasn't been tendered. Thank you.
Well, I will say this, and this is very, very important to point out, and I think sometimes reviewing trial courts fail to understand that sometimes trial judges are being dropped specific issues in their lap, and I don't have had an opportunity to review that case. I don't know what the Ninth Circuit requires as far as jury instructions are concerned. Just as important too, and I don't know what the what state is that from?
Oregon, Your Honor.
Oregon. I don't know what the status of the case law is in Oregon, but Nevada case law appears to be fairly clear as far as what types of evidence in a strict products liability case pursuant to the restatement of torts 402A a jury may consider, right? And here's my point, going back to Krause. The Nevada Supreme Court permitted evidence to come in where a prior event couldn't even recall whether or not their knee hit the latch on the stairs. I mean, on the ladder, going down the stairs, or going down the ladder as they transversely to the ladder. And here's my point on this specific issue. And I look at it from this perspective. At the end of the day, when it comes to constitutional safeguards, there's a proportionality requirement as it pertains to compensatory damages. And I'm gonna follow the mandate of State Farm. Whatever arguments the lawyers make, in this case, I'm gonna permit them to do it from the punitive damage phase. At the end of the day, our Supreme Court's gonna have to look at this because there's some really unique issues, specifically as it relates to deterrence, one of the purposes of punitive damages, what happens when there's a bankruptcy filed, what happens to the annihilation component, and we've addressed all those issues. And so what I'm gonna do is this, I'm just gonna go ahead and proceed like I proceeded in prior cases. And ultimately, there will be appeals, and Supreme Court will have to grab it.
Thank you, Your Honor.
Thank you, Your Honor.
Really, just a short break, Your Honor. Use the restroom.
Anything else?
Your Honor, going forward, depending on what the jury comes back with, we're gonna still, at least me, we're gonna need
Mr.
some.
Eckler, yes, of course.
Okay, perfect. Thank you, Your Honor.
No.
Oh, you letting him go? I thought you were saying
He
yeah.
has
me
a
too.
more pressing issue.
You go right ahead. So, Your Honor, depending on what the jury does, of course, if they return a verdict that includes a punitive damage phase, I'd actually let them go to lunch, and so we can get prepared after lunch for the.
Why don't we have to go to lunch? We can't play rich.
We can play Rich. I'm talking about after that. We
Okay.
play Rich, Mark Rich, deposition testimony or trial deposition testimony, and then after that, before we present our arguments, we let them do lunch.
In essence, you want a break. You want a break too, huh?
No, Your Honor, because when this was broached with the jury, it made it very clear by Mr. Parker, hey, it's gonna be an hour, we'll just get this thing on, we'll get moving. They've been working on this, I guess, and making rulings for themselves, and agreeing with the court on rulings before you even made a ruling, that they've been through this 3 to 4 times. They're gonna roll out the same dog and pony show. There's no reason to keep this jury any longer if they award a punitive damage phase. We're ready to proceed. That was the whole point of getting wrapped up, pushing everyone through the closing so we could get out of here today.
But I don't think you're necessarily ready yet, sir, because the videotapes haven't been even edited yet.
Yeah, Judge, it's gonna, the natural sequence is gonna take us to lunch anyway.
The other thing is, Your Honor, when Mr. Johnson
The only reason I
needed
bring
time
that up-
to.
Hold up, Mr. Johnson, you weren't here when they were going through the edits. And
I got the tail end of it, but I would assume that based upon the mass edits that were done on that, that would be done by now. It was, if this deposition was 50 pages, I imagine we're down to 12. But,
Going through now.
you go-
11 pages now.
11 pages, okay. So, I guess we can address that when we get to it, Your Honor, but my preference is to press forward, but it's the court's ultimate discretion.
Yeah.
Judge, it's 10:48 now. After we hear the verdict, it's gonna be at least 11:15. Playing rich is gonna take,
Whenever it
at
takes.
least 15, 20 minutes. We're already at 11:40. The natural order of things is gonna take us to lunch.
Well, it was also represented that there was going to be one attorney for the plaintiffs arguing punitive damages. Now, it seems like Mr. Eglett is going to do one as well. Is that true?
I'm doing it.
All right, so it's not Mr. Parker.
Mr. Parker's doing the rebuttal.
Okay. Again, not what was represented in terms of how long this was going to take, but again, it's court's discretion.
well,
Your Honor, you've given Mr. Johnson a reprieve when he
I've
needed
given
more time.
everybody a reprieve.
Exactly, when he needed more time to do his closing.
Well, I mean, for example.
We stopped an hour early.
The plaintiff wanted to go right then and there,
That's
and I
correct, Your
thought
Honor.
it was fair for Mr. Johnson to come
Thank you.
back and do his closing the next day.
No, no,
That's
ask
right.
for a reprieve. I'm in the
No,
same
no,
boat as
nobody's
everybody
saying-
else.
No, nobody's saying you asked for a reprieve. I was just doing what I thought was appropriate.
Like I
Because-
said, Your Honor, it's up to you.
Yeah, and so, and that's kind of my point. It was fair to you not to go into your closing at 4 o'clock in the evening and come back the next day. That's how I looked at that, and that's exactly what we did. So when it comes from timing issues, of course, I would love to have it done very quickly. But in the natural progression, we're talking about closings, right?
Yes, Your Honor.
Yeah, I mean, we have to watch the video, we have to see what the verdict is, who knows, it might be moved, I don't know. You know?
What?
All right, John.
All right.
Because he knows the case.
So,
You don't know
here's
the
my
case.
next question.
No, you don't. I do too.
Are we ready for the jury?
If that's
Yes,
what
sir.
you want him to do it, go ahead.
Plaintiffs, are we ready for the jury?
Well,
Okay.
you ready for the jury?
Yeah, we're ready.
Thank you, sir.
Oh, Your Honor.
Well, you better tell the
All
judge,
right.
you better tell them and tell the judge about it.
So, I'm gonna step down for 1 second and talk to the marshal. So,
Thank you.
Thanks, Your Honor.
Step out, I thought you two guys. Well, I think we decided to do it. If that's what you guys want to do it, I'm fine. No, I'm fine. He's gonna do everything. Okay. If you guys got it figured out, it's fine. I'm just, no, whatever you guys want to do. Well, I haven't seen what you guys prepared. How come we got
I'm working on my own. He's mine. That's the other reason. He says it'll take like 30 minutes.
What'd you say?
He said he's gonna take like 30 minutes to finish my
you're bringing in the jury.
I'll go grab the defense counsel.
I don't know, I didn't see you either. Let's go through the designation.
these decisions on the fly. Where is Esposito?
You know, I've done this job too many times.
Were you nervous the first time?
It's okay. Yeah, I was nervous about that. When I was working instrument case, you know. I have a tough case. That was. Mm-hmm. You're good, just like you asked for.
15.
All right, for the jury. All right. Oh, you may be seated. All right, do the parties stipulate to the presence of the jury?
Yes, Your Honor.
You do, Your Honor.
All right, thank you, counsel. Anyway, ladies and gentlemen of the jury, did you have an opportunity to select the foreperson? Is that a yes? And who's the foreperson? Is that Mr. Dixon? All right, thank you, sir. Anyway, Mr. Dixon, has the jury reached a verdict in this matter?
Yes, we have, Your Honor.
Okay, can you hand that to the court martial? Thank you, sir. No, it's in order. And at this time, we'll have the court clerk read into the record the jury verdict.
District Court, Clark County, Nevada, case number A-21-831725-B, Department 16. In the case of Nicole Chang, an individual, Andrea Bourdonnais, an individual, Nigel Davis Richard, an individual, James Delmar, an individual, Vanya Diaz, an individual, Kathleen Gassias, an individual, Lisa King, an individual, Ginger Land Van Buren, an individual, Carrie Mano, an individual, Glenn Morris, an individual, Cheryl Nally, an individual, Abraham Olvera, an individual, Carolyn Strong, an individual, plaintiffs versus AffinityLifestyles.com Incorporated, DBA Real Water, a corporation, Real Water Incorporated, a corporation, defendants, special verdict form. We, the jury, return the following verdict. Compensatory damages. Fill in the amount of the damages for each of the following plaintiffs' past physical and mental pain, suffering, anguish, disability, disfigurement, permanent injury, and loss of enjoyment of life. Lisa King, $1 million. Andrea Bourdonnais, $500,000. Nicole Chang, $200,000. Nigel Davis Richard, $175,000. James Delmar, $75,000. Vanya Diaz, $300,000. Kathleen Gassias, $0. Ginger Land Van Buren, $200,000. Carrie Mano, $100,000. Glenn Morris, $75,000. Cheryl Nally, $80,000. Abraham Olvera, $200,000. Carolyn Strong, $30,000. Fill in the amount of damages for the following plaintiffs' future physical and mental pain, suffering, anguish, disability, loss of enjoyment of life, and psychological expenses. Lisa King, $40 million. Fill in the amount of damages for the following plaintiffs' future physical and mental pain, suffering, anguish, disability, loss of enjoyment of life, and medical expenses. Andrea Bourdonnais, $20 million. Fill in the amount of damages for each of the following plaintiffs' future physical and mental pain, suffering, anguish, disability, loss of enjoyment of life, and medical and psychological expenses. Nicole Chang, $2 million. Nigel Davis Richard, $3 million. James Delmar, $500,000. Vanya Diaz, $5 million. Kathleen Gassias, $0. Ginger Land Van Buren, $3 million. Carrie Mano, $500,000. Glenn Morris, $300,000. Cheryl Nally, $1 million. Abraham Olvera, $250,000. Carolyn Strong, $100,000. Punitive damages. Is Real Water liable for punitive damages? Yes. Dated this 21st day of March, 2025, signed jury foreperson. Ladies and gentlemen of the jury, is this your verdict as read?
Yes.
Thank you.
Do either of the parties want to have the jury polled at this time?
No, Your Honor.
No, Your Honor.
All right. All right, ladies and gentlemen, thank you for your hard work, but we're not done. And I think you know that, right? We're not done, but we hopefully will be done today. And counsel, can we approach this real quick? Any idea where we're at as far as the edits are concerned? The edits. Do we know where we're at as far as the edits are concerned?
I don't know, Your Honor, but I know that Mr. Parker needs to go to the comments building.
With the edits?
Yeah, I just got confirmation.
Okay.
All ready, that's what Tyler said. So we can play that.
Yeah, this is what we're gonna do. We're gonna play that. How long is it?
Should be about 15 minutes.
Okay.
You take lunch after
Yeah,
that?
we're gonna take lunch and then we'll come back. All right. Okay, ladies and gentlemen, at this time, we're gonna go into the next phase, and it's my understanding we do have evidence we want to present by a video deposition. Is that correct, counsel? Is that a yes?
Yes.
Okay. All right.
We're just turning the TV on, Your Honor.
I understand, sir.
Raise your right hand, please. Please swear to tell the truth, all the truth, and nothing but the truth, so help you God.
I do.
Thank you.
Good evening, Mr. Rich.
Good evening.
We are here to take your trial testimony in this matter. Do you understand that?
Yes, I do.
Okay. So, Mr. Rich, can you tell the jury what your profession is?
I'm a certified public accountant. I'm also certified in forensic accounting.
And what's the difference between those two?
CPAs typically in that line of work, we deal with taxes and audit and, traditional accounting type services. Forensic accountants, we deal with more complex matters that include, for the most part, larger dollar amounts as well.
And how many years of experience do you have?
I have over 40 years experience as a CPA and over 10 years experience as a forensic accountant.
And who certifies you in the forensic accounting environment?
The American Institute of CPAs, what we also call the AICPA.
And what are the requirements to be able to qualify for such a certification?
There's testing, same as with the CPA exam, when you have to pass your boards, the same thing as forensic accountant. And then also they look at your body of work in that area.
Okay, Mr. Rich, let's get to the reason why we're here. You were engaged to take a look at this case and give an opinion or a determination as to the bottled water industry. Is that a correct statement?
Yes.
And have you done so?
Yes, I have.
Did you look at Coca-Cola, Pepsi, Nestle as examples of the bottled water industry?
Yes, they're probably the largest players in the bottled water industry.
And based on your review of the bottled water industry, have you come up with some form of opinions in terms of the size of the bottled water industry?
Yes, I have. The bottled water industry is anticipated in 2025 to be a $350 billion industry globally. In the US, greater than $100 billion in 2025. It's anticipated that it will have 6% growth over the next few years, and by 2030, it's estimated in the US that the growth will be to 135 billion.
Thank you. So let's just focus on the US at this point. It's my understanding, based on what you just said, that the US bottled water industry is about approximately a little more than 100 billion at this point in time?
That's correct.
And do you give that opinion to a reasonable degree of forensic accounting probability and or certainty?
Yes, I do.
You've authored a report related to your opinions, correct?
Yes.
And have you ever done an analysis based on the appropriate amount for punitive damages in a lawsuit?
Yes, I have several times.
And did you do a similar analysis in this case?
Yes, I did.
Based upon your analysis in this case, and based upon the bottled water industry, what type of punitive damage award would be necessary to have a positive effect on the industry?
My findings indicate that it would need to be at least a $2 billion award to have any meaningful deterrent effect on the multi-billion-dollar bottled water industry.
And even a $2 billion award is only, what, 2%, or less than 2%?
It's less than 1% of those companies, which include Coca-Cola, which is Dasani, Pepsi, which is Aquafina, and Nestle. It's actually less than 1% of their overall value of those companies.
And so even a $2 billion award, given the size of the industry, would be fairly nominal from a financial accounting perspective, correct?
That's correct. That's why I say it'd be at least $2 billion to have an effect.
And Mr. Rich, is the alkaline bottled water product, is that simply a part of the bottled water industry?
Yes, it's a part of that $100 billion in the US and also a part of that $350 billion globally.
So your opinions that you've given about what impact or what amount would be necessary to have a positive impact on the industry, that was for the entire bottled water industry, regardless of the type, correct?
That's correct. That includes spring water, alkaline water, vitamin water, etc.
And so be it a larger, middle size, big size, regardless of the size, they all make up part of this overall bottled water industry, correct?
That is correct.
And they're all competing for the same greater than $100 million worth of the market share.
Yes, in the US, absolutely.
Thank you, Mr. Rich. Those are all the questions I have.
Thank you.
Good evening, Mr. Rich. My name is Brad Johnson. I represent the defendants in this lawsuit. Can you hear me okay?
Yes, I can. Thank you.
Okay. Thanks for making yourself available at this time. Mr. Rich, Ms. Peppermint indicated that you had authored a report in this particular case. Is that correct?
Well, I think he's referring to the report I issued on June 21st of 24.
Okay, and I have that in front of me. That's a 4-page report.
Actually, it's more pages than that if you consider the exhibits and such.
All right, but if I consider the exhibits, it would be what looks to be an approximate 42-page report. Is that consistent with your recollection of your report?
Yes, at least, yes.
Okay. So, have any of your opinions in this June 21, 24 report changed?
No, they have not.
And you have not made any supplements to the opinions in that report as well, correct?
No, I haven't. I have included, the information through 2025. That report was through what we had available in 2024.
Okay. But again, my question is, we talked about how long your report is in the exhibits. Have you supplemented the report in the exhibits beyond that I've described?
Not that I recall.
All right. So you had indicated that you, as I looked at your report, is it not true that you were directed by plaintiff's counsel to look specifically at the largest companies who make bottled water?
That's correct. Nestle, Coca-Cola, and Pepsi, yes.
All right. And to determine the financial status of those particular companies, I believe you stated you did Google financial reports on those three companies. Is that accurate?
Well, actually, it's based on the cap value. So the cap value is stated daily. It's based on the trading value. And so that report is as of that date. And then as of today, it hasn't changed significantly in terms of the market cap of those three entities. I don't think anything will change it in the near future.
Okay, but our recollection was that you obtained that information for something called Google Finance Reports. Is that not accurate?
Yeah, I believe so. It's readily available. Yeah.
All right. It's readily available to anybody. You also did some research on the bottled water industry through Dun and Bradshaw, is that correct?
Bradstreet.
Excuse me, Bradstreet?
Yes, that's correct.
All right, so to the extent that you or your company or your firm did research, it was on readily available internet type searches through Google Finance Reports and Dun and Bradstreet.
Well, we subscribe to Dun and Bradstreet, and market cap is readily available to anybody, anytime, with just a click of a button. That is correct.
All right. Now, you're not specifying a dollar amount or suggesting a dollar amount to the jury or the court, correct?
No, I just am pointing out what would be meaningful in terms of a deterrent and an effect on a multi-billion-dollar industry. That's my scope.
I'm sorry. When you use the word meaningful, you also use the word positive impact. Are those synonymous in your opinion?
I would say so in terms of being a deterrent, yes.
Okay. So what sort of accounting standards did you use to come up with what a positive impact would be?
Well, it's based on my 40 years of experience, my over 10 years experience as a forensic accountant. And I think in this particular case, I believe that a common sense approach as well in acknowledging that $2 billion in this industry as a deterrent to these types of companies is, relatively small in comparison with their overall value.
All right, and I can appreciate that's your opinion, but again, there's no place in there. Are there standing accounting practices that you have to follow?
In terms of my opinions, no.
No, as a CPA?
Yes, we have various standards. That's what the AICPA regulates, yes.
Okay, so I'm going to start with the CPA aspect of your work. Is there something within standard practices for CPA defining what a positive impact would be?
Well, I think there's not necessarily a standard. I think it's common sense meaning. Do you not understand what that means?
Is there a standard in your practice of an accounting that defines the term that you're using, positive impact?
Well, I'm not quite sure what your question is, but CPAs like myself and experts, we use terms all the time that you won't find in, rules and regulations and things like that. I think that's acceptable for me to have an opinion. And it's acceptable under our standards for me to state it the way that I see that others would understand it, like yourselves.
I'm going to ask you the question until you give me an answer. And these rules and regulations that you just mentioned, the rules that govern CPAs, is there a definition in those rules and regulations for the term positive impact?
I would say no, and I would say also it's not necessary to have any rule or regulation on each word that we use in a report.
Okay. All right, but it's your word, positive impact, that you believe is the crux of your testimony. What would be a positive impact in terms of a punitive damage award, correct?
Well, I would say the definition, once again, in my report, is a meaningful deterrent effect. And I think that's really what we're getting at, is what would be a meaningful deterrent that would have a positive impact on the industry to prevent this from happening, you know, on a larger scale or smaller scale with another bottled water company.
Okay, and I take it there's no guidelines that you have as a CPA to determine what a deterrent amount would be. That's your subjective belief, correct?
As CPAs, especially experts in different areas, are given, you know, the ability to express our years of experience and our analysis. Absolutely, that's correct.
So that answer would be yes.
Yes.
Okay. Now, this aspect of your testimony is as a CPA or a forensic accountant?
I think it's as both. As a forensic accountant, that includes a research type aspect. As a CPA, it also includes an understanding of the value of companies and the impact in this type of case based on values. What we call the value.
And in that regard, did you have someone in your office do that research?
I do the research myself.
You didn't have any help on your report?
Of course, we have people that assist us just like you do, of course.
Okay, but also, I don't know that. What part of your help, or excuse me, your report did you get help from? Or excuse me, help for?
Well, everything we do is reviewed for spelling and things of that nature, and for grammar and for understanding. So of course we use other people. These are my thoughts, these are my conclusions.
Okay. Do you have an understanding of punitive damages and how they're used in the United States?
Yes, I believe I do.
Okay, what is that?
Well, punitive damages, it's really to serve, exactly as I've said, as a deterrent. I think it's exemplary in that punitive damages are to prevent, it's to punish and prevent it from happening again. And it's used as an example. Don't do this, like in this case.
All right. Are you aware of any safety concerns that Coca-Cola has experienced related to its bottled water manufacturing?
I'm not aware of any specific, no, I'm not.
How about Pepsi?
No, not any specific safety concerns. I'm aware that all these publicly traded companies do have safety concerns, as does Nestle, but I'm not aware of a specific safety concern.
How about Nestle?
No, I'm not aware of a specific safety concern by Nestle.
You had indicated previously in your testimony that you believe that punitive damages are related to at least partially a deterrent factor. Is that correct?
I think that it should be, there should be a deterrent. I think people should, these bottled water companies should take a second look, especially at this case, and see that, you know, there is a possibility, if they're not careful, that something could happen to them. So I believe it definitely does have a deterrent on all these companies.
Okay, so what specifically would Coke be deterred from doing in this case?
Managerial issues over their employees, training issues over their employees. I think those are all things we can all learn. I know that I don't look at bottled water the same as I did before this case or the other cases. I don't.
Okay.
And I don't think they will either. I think industry-wide, this is something, I know in my own industry, I'm sure in your industry, things that happen, it creates change. And especially a well-known case creates change, and it does have a meaningful deterrent effect. That's not only my opinion, that's in my experience.
I don't have any further questions, Mr. Rich. Thank you.
Thank you.
Just a few follow-ups, Mr. Rich. Your opinion that the bottled water industry is more than $100 billion in the United States, does that include all companies, big, small, medium, within the industry?
Yes, it does.
And in the specific financial information that you provided related to Coke or Pepsi or Nestle or Dasani in your report, does that have anything to do with your opinion that the current market value of the United States bottled water industry is in excess of $100 billion?
Well, it wouldn't be the market value, but that is what the industry is in terms of overall revenues is $100 billion.
And I apologize, thank you for that clarification. The overall revenue of the bottled water industry, big companies, small companies, and medium companies in the United States is presently at over $100 billion, correct?
And anticipated to grow at 6%. Between now and 2030, the estimate will be $185 billion. Yes.
And the market caps of Coke, Pepsi, or Nestle, does that have any relevance to your opinions on the overall revenues of the bottled water industry?
No, it does not.
Okay, thank you, Mr. Rich. No further questions. Mr. Rich, the companies that you referenced, Coca-Cola, Pepsi, Nestle, those are companies that are part of the bottled water industry, correct?
That is correct.
You were asked to look at the type of punitive damages that would have a beneficial impact on the industry. Is that a correct statement?
Yes.
Okay. And that industry includes companies such as Coca-Cola, Pepsi, Nestle that we discussed, correct?
That's correct. Yeah.
Thank you, Mr. Rick.
Okay, thank you.
Thank you, Mr. Rick.
Is that the end of the video?
I believe so, Your Honor.
It is, Your Honor.
All right. And can we approach?
Lunch is on its way. It's not here yet, Your Honor, so I think at least an hour. Is that lunch?
No,
Lunch
I
is
get
not
that.
here.
What is the anticipated arrival when you find out? I've already. I think this is how it breaks down to everybody. Am I wrong on that?
Yeah, that's right. Yeah, that's right. 285 was the first one. The second one, Frank Kisher, was 30.
Well, I think these are the three that are in front of me.
Yeah. So this is the,
It wasn't the Brown case.
what the Brown case?
It wasn't the Browns.
Yeah, the Brown case was the training.
That's a different issue.
What was this one about the fee?
Well, King was 41 Anyway, what we'll do, so we say 20 minutes, you know, yeah, they're not here.
It's about 15 minutes.
Okay, because I want to tell the jury what we're going to do. We're going to break, they'll get their lunch, and then we'll come back. What do you think? 12 up? Mr. Johnson, what do you think? I want to keep you in the loop on this. Lunch will be here within 15 minutes. If it will. Yeah, I'm going to start telling my time this thing because understand this, and this is one thing I'm very sensitive about when it comes to counsel and having time to prep for closing. That's why I gave you overnight. Yeah, I've been saying, you know, and at the end of the day, I mean, because you know, this is what this overlook do. Is my staff. You know. No, I got that, but I'm just telling you, that gets over. So what we'll do then, I will tell the jury we're going to break to 12:45, right? and there'll be lunch coming shortly. And then we'll finish up with closings. Okay, ladies and gentlemen, this is what we're gonna do, because it's my understanding, lunch will be here very quickly. I just wanna let you know that. And so, I'd rather you eat your lunch fresh versus leaving them sit as we go through the next phase. We're gonna break right now, and we'll reconvene until 12:45. At 12:45, they'll do their closing arguments, and then at that point, you'll have one deliberation left. You understand? So anyway, ladies and gentlemen, you're admonished not to converse amongst yourselves or with anyone else on any subject matter connected with this trial, or to read, watch, or listen to any report or commentary on the trial by any persons connected with this case, or by any medium of information, including without limitations, newspaper, television, radio, social media. Remember the prohibition. Last but not least, do not express any opinion on any subject matter connected with the trial until the cause is finally submitted to you. And we'll have you go back to the jury deliberation room, and lunch will arrive shortly.
All right, the jury?
Oh, whatever.
Change off of this thing worked out.
No. Wait till the original first.
Yeah, we'll talk
Because we're going
about
back to the deliberating. Right. Well, no, but it's easier just to keep it there.
Okay.
Yeah, it's easier, but you don't want to go ahead and take let's go.
But I gotta. Hey, appreciate
Because who knows, they might need part of it for the deliberations and Trinity. No, they won't deliberate until closing.
Wait, hold on, sorry. I have the original Declaration for you. Thank you.